Yes?
This meeting is being transcribed and summarized.
Morning, everyone.
Oh, okay. Got it. All right, are we ready to begin? Yes. All right. All right, are we on the record? Luis?
Yes, sir. I've started the recording.
Okay, thank you. So we're here this morning in the application, um, in the case of application of Yucca Growth Infrastructures LLC, AQB 26-57P. This is the applicant's request for an emergency status conference. My name is Max Shepard. I am the hearing officer that Director Kinney has appointed to preside over this case. And even though I know we have several people participating, I would like for all the parties to enter their appearance at this time. And you're going to have to, I don't have your names on my screen, so you're going to have to just sequentially work through the parties and then your appearance. And if you do that now, I would appreciate it.
Mr. Hearing Examiner, this is Jennifer Bradfute and David Kermsey on behalf of the applicant, Yucca Growth Infrastructure.
Okay.
Good morning, Mr. Hearing Officer. This is Colin Cox for the Center for Biological Diversity.
Next.
Good morning, Mr. Hearing Officer. This is Maslin Locke. I'm here with my co-counsel, Eric Jantz, on behalf of Jose Saldana Jr. and Vivian Fuller.
Okay, thank you.
Good morning. Hello, my name is Nicholas Maxwell. I am a pro se intervener from Lee County. Thank you.
Thank you.
Good morning. This is Chris Vigil from the New Mexico Environment Department. I'm here with Brian Yardman Frank. Thank you.
Good morning, Hearing Officer Isaiah Zemke, Business Manager, Finance Secretary, Treasurer of Sheet Metal Workers, Local 49.
Thank you.
Good morning, Hearing Officer. This is Iwei Chen here on behalf of New Mexico Economic Development Department.
Okay.
Good morning, Hearing Officer. This is Courtney Eichhorst with New Mexico Building and Construction Trades Council.
Thank you.
Good morning, Mr. Hearing Officer. I am Nat Jakeris in a limited appearance on behalf of the New Mexico State Engineer's Office.
Good.
Good morning, Mr. Hearing Officer. This is Bruce Weatherby, appearing pro se.
Good.
Good morning, Mr. Hearing Officer. Andre Makarski, Local 412 Plumbers and Pipe Fitters Business Agent.
Okay, thank you. Now, does that seem to be it?
Good morning, Mr. Hearing Officer. This is Carlos Romo at Williams, Weiss, Peppel, and Ferguson, also on behalf of applicant YGI. And my colleague, Jennifer Beaver, is having a little bit of trouble getting on the WebEx, so she'll either join here in a minute or join via phone call.
All right.
I am here, hearing officer. This is Jennifer Beaver. Thank you.
All right, good. So here is the way that I propose that we're going to proceed this morning. I'm going to kind of go through the parties' positions as they've been presented in the motion and response to the motion. Ask questions that I don't have answers to at this point, based on what's been presented in argument. And then give the parties a chance to present further information if they want to, and rebuttal information to that. And I'm going to start with the request for emergency status, the motion filed by the applicant, and would have to say that Ms. Bradford's motion, which was very well written and helpful, pretty much speaks for itself. Obviously, the applicant's concerned that the hearing date that I set in October 19th is not going to give the parties and the deputy director sufficient time to meet the statutory requirements to enter a decision by November 23rd. And I have read the rules and your cites in the motion, Ms. Bradford, and I found them most helpful. As you may or may not know, I've been a hearing officer for 17 years, but I've worked primarily with regulation and licensing department, hearing cases with them, and haven't heard cases in the environment department since probably 5 or 6 years ago. So bringing this issue to my attention is appreciated. I don't have any real objections to your presentation, Mr. Bradford. In fact, I think it's quite good. I do have some exceptions to your allegations of prejudice, but we will get into that a little later. What I'm more concerned about actually is what's been presented by the parties in opposition to resetting the hearing date. Those parties have consistently argued that if the hearing date is set back to the August date that was initially proposed, that will deny them due process because they will not have adequate time to have prepared and presented their case. A couple of things that I have issue with in those allegations. First, the New Mexico Environmental Law Center makes a statement in their responsive pleadings that the 180-day rule of 20.2.72.207B, that rule simply does not apply once a petition, an application, once an application has gone to hearing. I don't find anything in the rules that supports that assertion. And the assertion is made in the responsive pleading without citation to any case law or any rule. So save that because I certainly have an issue with that statement because it does not seem to be supported by anything that I can find. The other issue that I have with some of the responsive pleadings that have been filed by the parties opposing this rescheduling motion is that they've cited to the case of associated asphalt and materials. And admittedly, that case went 580 days from the notice of completion to the time that they finally had a hearing, which is interesting factually. But again, the parties didn't cite me to any, and that particular document is paginated. So you could have cited to a page number if there was anything in that document that you wanted to call my particular attention to. There were no page numbers cited in the responsive pleadings, and I didn't find anything in that 2,700 page document. 2,700 page document. Come on, guys. 2,700 page document that supported, well, no, that in any way discussed why on that particular case there was a 180-day lapse between the notice of completion to the time that an order was entered on the application. So while it may be factually interesting, it doesn't in any way help me decide the issues of this case, because there's nothing in there to explain why that happened. And I'd like to switch over to Mr. Vigil at this point, because while the department filed what I would call, an information response without really taking a position one way or another, other than the fact that they are prepared to proceed and will file the draft of the permit and the analysis of the application by the 29th, is what they're asserting in their response. I'm wondering if the department has ever had cases like this asphalt case where the hearings just went on and on and on. And is that a practice that is accepted in the environment department?
It's the norm.
I mean, do you know? And if you know, what's the answer?
I do know. It is the norm. Cases do typically, go beyond. Sometimes we seek agreements with the party to extend them. And other times, there is, what you might call constructive waiver. The parties are participating and the time goes by, and I think it becomes impossible. Well, I'll just say, and this has nothing to do, I'm not commenting on this case whatsoever. Typically an applicant, and again, I'm not speaking about Yucca, typically an applicant wants the permit and they will continue down the road until they get their permit, right? And so there is a kind of constructive waiver there. There are cases in which I think the Roper case would be another one in which there was an objection by the applicant. And if I remember correctly, and I'm not sure I do, that there were a formal waiver of the deadlines. It's the party's right, and so yes, it is the norm that these cases go on, whether through constructive waiver or through a formal waiver. It is the department's position, and this is sort of why we stayed out of the fight, but we wanted to say something, and a statement of position seemed to be the fairest way to do that. It really, the way the department sees it, and me as an attorney who does this, these deadlines protect the due process rights of the applicant so that we don't sit on this forever. And so there, now this does not take away the due process rights of the parties. They have a different argument about different deadlines. And I'm not taking a position on that either, but I do want to say that the department, we're trying to be mindful of the right of the permit of the applicant at Yucca, because Yucca doesn't want to extend it. And so, it's like I said before, and I'll end here. We're in a difficult position, is kind of balancing as a state agency between respecting the due process rights of Yucca and the due process rights of the challengers. It's a sticky situation. So I don't know if I answered your question, but
You did, but I have one other question. I mean, for example, in cases like this asphalt case, is there a discussion of Rule 74-2-7 or 20.2.72.207B1? These rules that say it has to be decided at a certain time, and there's only one extension granted, and there's nothing in the rule that mentions or seems to authorize a second extension of time. I mean, did those discussions come up, or they're just kind of swept under the table or under the rug, and you just moved without considering whether or not you're violating the rules applicable to these hearings?
no, they're not swept under the rug. And sometimes, as I said before, the discussions do come up. And when an applicant raises a concern, and when it's clear, and this is not about this case, but in previous cases, when it's clear that we're not going to be able to meet the deadlines and an applicant is raising the issue, then, we will enter into a kind of, a waiver, where we will file a joint waiver of the deadlines, right? Or a motion, actually. We would have to do a motion in front of the hearing officer, whether it's before, well, we'll just stick to the environment department permitting rules. So we would file a motion to the hearing officer, a joint motion requesting that there be waived, and there's an order waiving the deadlines, and it could be, permanent waiver, or it could just be extension of the deadlines to whatever else. But, in the other cases, it's not necessarily that it's swept, but, it's been the department's position that there is constructive waiver. If you're still participating and you sleep on your rights, or, I don't know if that's the right way to put it, but if you don't raise an objection, then yes, we continue down the permitting road. And, most of the time when people get their permits, they're not going to go and complain, well, I got my permit, but I didn't get it fast enough, so now I'm going to take you to court. I think it's much more likely when they don't receive a permit, that's where these types of defenses and arguments can come from. Again, I don't know if I'm answering your question.
No, you perfectly. Thank you.
If I may also,
I'm sorry, and who is this? I don't see you on my
Jennifer
screen.
Bradford, I'm sorry, with the applicant.
Yes, hi. Good morning.
Good morning. We did look for cases from the department where an applicant has refused to waive their right, because here is a fact pattern where the department has stated affirmatively that they're ready, willing, and able to meet the deadline. So there's capacity. We couldn't find other cases where that was the case, where the department was ready, willing, and able by the deadline, and where the applicant also said that they wanted to enforce the deadline absolutely. And deadlines in this project are highly important. So this project, my clients are not willing to waive the deadline. We want to enforce the deadline. And that is really the distinction. So I think about it kind of like a statute of limitations issue. As lawyers, we have deadlines all the time, right? And that does not mean they're not legally enforceable by a judge. Judge sets that period of time. The legislature, Congress sets a period of time. We have to abide by it. But there are times when an applicant can waive a defense, like a statute of limitations defense. You don't raise it in an answer and you proceed, or you affirmatively waive a time period. That is not what's happening here. Here you have both the agency and the applicant saying that they are not waiving the timeline. Yeah.
And let me go back to something. I missed the beginning of your statement there. What did the cases that you were looking for? Did you find cases that had this fact pattern? And if you did, what was the holding or ruling in those cases?
So I don't find a discussion of the rule or the statute, but in the Associated Asphalt and Materials case, there was actually a joint motion by the parties to go beyond the 90-day extension period. I did notice that case, the permit decision happened right after March 13th, 2020, when the whole world shut in due to COVID. And so I think it ran around March 16th, 2020 would have been the first 90-day time period. I, like you, did not find a conversation as to why they extended it. I assume that the parties probably talked about COVID and the uncertainty during that time frame.
Maybe so. Maybe so. Okay. Um,
And Mr. Hearing Officer,
Yes.
just for your information, I was the attorney on the Associated Asphalt and the Roper. Most of the air permitting cases, I've been the attorney with a few exceptions.
Okay. All right. Thank you. Let me ask Ms. Locke, I believe it is.
Yes, Mr. Hearing Officer.
Okay. So in your responsive pleading, there is this statement that I have referenced earlier that if a application goes to hearing, then the 180-day deadline does not apply. I didn't see any support for that statement in your responsive pleading, and I didn't find any support in the rules for that statement. So I'm wondering where it came from, and how do you support that statement at this point?
Certainly, Mr. Hearing Officer. I think the first thing that supports that statement is the fact that the rules seem very clear to me that you as a hearing officer have discretion to extend time upon request. I think it's also supported in the Associated Asphalt example. I was also an attorney on that case, and I'll just say, if you look at that example, and I understand it was lengthy, there was no discussion of extensions. Typically, in my experience, there is no real discussion of these extensions. But if you look at all the archived docketed matters for the department, these hearings typically, for much less complicated cases, Associated Asphalt was a much less complicated permit, and that took 580 days, as I said. Most cases take between 6 months and 2 years. So I think this sense of inflexibility, I guess, of the 180-day time frame being only flexible if an applicant agrees with that isn't fully supported when the department's pattern and practice is almost always going beyond that 180 days. And I think this sense of urgency, while I can understand any prejudice to the applicant, it's ultimately the applicant's decision to put the cart before the horse, which they've done this entire time. And they're stressing the urgency and leaving out the fact that many other issues are popping up with this project that are going to delay it. So rushing this particular hearing, at the risk of creating several due process issues for many community members and other parties involved, just doesn't seem worthwhile to me. I think it's interesting that the department is saying they're ready to move forward, yet they haven't actually released any of the information that all the other parties need in order to meaningfully prepare for a hearing. I think it's interesting that there's this idea of constructive waiver. I've never really heard about that, but I think most typically these hearings take a long time because they're complicated and people need time.
Okay. Well, I'm sorry that the department has not released its analysis of the petition and its draft permit yet. For whatever reason, I know that is necessary for the parties to review before they can actually, well, not before they get started, but certainly it's necessary as part of their preparation for the case. And I do hope that the department does intend to release those on the 29th. Still, Mr. B. Hill, is that correct?
On or before the 29th. Yeah, it's imminent. With the notice and releasing it was delayed because it seemed like we had at some point, it seemed like we had till October 19th. Now maybe we do, maybe we don't. Yeah, and then the department statement that it's ready is just more of like, we're ready to go. We're not saying that everyone else is ready to go. Let's go. It's just a statement that the department itself, we're ready to go to hearing. We're prepared, and of course, we have an advantage, right? So I want to acknowledge that, but it's not a statement about the other parties. It's just an affirmative statement to you as something to consider.
Sure, understood. So then the other possibility, which hasn't, sort of is implied, I guess, but hasn't really been fleshed out, particularly in the responses filed by the parties opposing. The parties opposing, of course, are asking that at least the October 19th date be held, and that we do not go back to the August 17th beginning date, based on a due process argument. And due process, we're all familiar with due process. It's been around forever. We all respect it. It's critical to the whole proceedings. But none of the, and again, it's not necessary. I would have liked it, I guess, if the parties opposing had found some cases that substantiated the proposition that a due process would supersede an administrative agency's rulemaking, administrative rules. If those cases are out there, I'm sure those cases are out there. None of them were cited. That would have been nice to have had one. I don't think it's really critical because we're pretty aware of what due process stands for and how it works. Certainly I am, having worked in criminal law for about 20 years. But the critical issue with a due process argument that isn't discussed in any of the opposing pleadings, filings, is it implied that if an extension is granted on due process grounds, then the deadline rules are no longer controlling. If a due process extension is granted, then as I say, the deadline rules are no longer controlling when a decision has to be made. Is that implied in the arguments of the parties opposing this? It's not spelled out. I mean, so I'm guessing it has to be, but I don't know that that's your position. Anyone?
Mr. Hearing Officer,
Yes,
this is Colin Cox with the Center for Biological Diversity. I think one of the issues is that the rules themselves, so there are due process rules. So like the motions rules, for example, give parties certain amounts of time to respond to pre-hearing motions, to write them, to respond to them, to reply to them, right? It's a three-step process. There's lots of time built in there. The hearing that they're asking, so if we take the applicant's thing that the 180 days is the sacrosanct rule, and it's all that matters, that then obliterates time for pre-hearing motions, for example, right? So I mean, you would essentially, as Mr. Vigil suggested, kind of be balancing due process and balancing the rules. We would like enough time to respond under your October 19th schedule that you promulgated, which seems to me to be a very reasonable compromise position between wanting to get this done quickly and still giving parties adequate time to do something. I would, of course, like more time, and I asked for more time, but I accept October 19th. Even that shortens the time for responding to motions, pretty dramatically, in violation of the rules. And I haven't filed a motion complaining about that. I'm taking October 19th as a good compromise position that I'm willing to accept. I don't want to speak for any other parties. But this isn't just, there's not just one rule here, and there's not just one legal consideration.
Okay, well, but that doesn't exactly answer my question. Let's assume, let's have a hypothetical here. Let's assume that the parties opposing the applicant's motion that we're considering here today, that these parties present evidence other than just kind of general statements, are able to present specific evidence of their need for more time to prepare for this hearing. And based on that, I would have found that the hearing should be continued to this October 19th date, that would be a good date, and that the due process, that the applicant's due process rights would be infringed upon because they wouldn't be able to prepare for the case unless it's heard not before October 19th. Then does that due process determination of an extension eliminate the November 23rd decision date, in your opinion? Understand my question?
I do, Mr. Hearing.
It's not
I
hard.
do, Mr. Hearing Officer, and the answer is yes. I mean, as Ms. Locke had argued, you as the hearing officer have authority to create the schedule that works for this. And we've had, and Mr. Vigil has said, almost all of these permit hearings take much longer than this amount of time, and sometimes that's with the agreement of the parties, and sometimes it's not. We've also submitted a discovery request on Friday, and we would like enough time for that process to play out. Even if those deadlines need to be shortened, we can talk about that as well. But I think the answer to your question is yes. As the hearing officer, you have the authority to set a schedule that gives the parties adequate due process rights. And we're talking about a very brief delay from this 180 days. This whole schedule it's much less than the 580-day example that Mr. Vigil and Mrs. Locke have participated in.
Sure. Well, and to the applicant, I'm not done with this by any means, but I do have to say this seems to me to be an extraordinarily important case for both, really, for the applicant and for the state of New Mexico. This, from what research I have done, this is not only going to be the largest industrial project in New Mexico. This particular gas-fired oxide fuel cell installation is going to be the largest in the world at this point. There's not a larger one anyplace being installed in the world. Now, size only complicates matters when you try to extrapolate from small samples to large samples, in my opinion. And it seems like and they may have, and again, you will get to address this. I'm just talking about some of my concerns as a hearing officer, trying to be fair to all the parties and the state of New Mexico. It seems like that might be a difficult task, extrapolating from small to large. It may not be. It may be very simple statistical analysis. And I also wonder about I just wonder how much research has been done and how much needs to be done. And I guess in that point, I would ask the parties who are concerned about their due process rights and not being able to prepare for this hearing. I would ask for the parties at this point to be specific with me about what you have done, what you feel like you need to do, and realistically, not blowing smoke, realistically, when you think you can actually get your research done, your experts together, your tests done, et cetera, et cetera. And everyone who is participating in this hearing and is interested in a due process violation, I would appreciate it at this point if you would sequentially go through that and state your positions.
Thank you, Mr. Hearing Officer. Again, this is Ms. Colin Cox with the Center for Biological Diversity, if you don't mind me just jumping in since we've been talking. So I mean, what we have done, right, is we've had this application, I believe it was declared administratively complete in the last couple of days of May. We began reviewing it. It was published originally the last few days of April. We began reviewing it. We began talking with experts about it, trying to find people who have some expertise, which is it's very new technology, so there's not as many people out there with expertise. We've been talking to experts. So it was declared administratively complete in May. We had 30 days to prepare some brief comments. It's not a terribly long comment document, a dozen pages or so, 20 pages. Since then, we've now, we identified some issues. We've continued talks with experts. I'm working on raising money to pay experts, which, I'm not suggesting we delay the hearing for that, but you asked for what, I'm telling you very specifically what I've been doing. So we're talking with experts. We've talked with experts about what all is missing from the application. So one of our big issues, right, is there's a very little information in the application to determine some of the things that they claim. And so we've worked with experts to talk about what do we actually need to know to properly analyze this application. And our discovery request that we submitted to you for your approval on Friday. It kind of reflects those conversations. Those are the various things the unknowns, the pieces that are missing, like just as an example, right? Like they claim no formaldehyde emissions, but the test they performed in the application would not have captured formaldehyde. So we've asked for any additional data they have about tests that would have captured formaldehyde. That's a very small example, right? We've got several of those. It's a pretty narrow request. It's really focused on some emissions issues, and it's focused on a couple of supply chain issues, because whether they can build this in a reasonable amount of time is highly relevant to NMED's permitting decision per the rules, and the rest of it's focused on air pollution, which of course is the main topic of this hearing. So what we really need from going forward is the response to those discovery requests. So that information that we've asked for, we would need that. And we would want to put that in front of our expert. So we need the discovery responses, and we need the department's analysis, technical review, statement of basis, and draft permit. And I would need to put all of those documents in front of my expert, and ideally give him at least 30 days. To develop our full testimony. And your current October 19th schedule with direct testimony due at the beginning of October is basically that, right? If assuming that the applicant takes 30 days from now, roughly it takes roughly the month of August to reply sufficiently to our discovery request, and assuming they comply in good faith and turn over all the documents and we don't have to fight about it, then we would be getting the documents at the end of August, and that would give my expert just over a month, like a month plus a couple of days, to review those discovery requests and develop testimony around them. And then we'd have things due in early October. That's workable. That's quick. That's probably as quick as I've ever done one of these hearings. It is quicker actually than I've ever done one of these hearings, but that's what we need at a minimum. And so any deadlines earlier than that, I think would be extremely challenging. Because there's a lot of information we don't have and that we are waiting on from the department and from the applicant.
Okay. Ms. Locke, anything to add to that?
Yeah, thank you, Mr. Hearing Officer. I'd say similar to what Mr. Cox said, we've been talking to our own experts and coordinating. The Law Center is a very small team, unlike the department and the applicant. So we just by nature benefit from more time. And you heard Mr. V. Hill say, the department and the applicant have a pretty significant advantage right now in that they've seen all the information while we have not. So a lot of, I think, the time that we need really depends on when things are released to us and how technical that information is. But I agree with Mr. Cox that the current schedule, as it's been set out with an October 19th hearing date, is the quickest I think we could accomplish anything in order to be meaningfully heard on the application.
Okay. Any other parties who want to address this due process issue at this point? I don't know that the new energy economy is present at this hearing. Anyone representing the new energy economy present? I didn't hear anyone sign in.
Mr. Hearing Officer, someone has their hand raised. I can't see who it is, but I just wanted to alert you to that if you hadn't seen it.
I had not seen it. Well, whoever has a hand raised, go ahead and speak up at this point.
Mr. Hearing Officer, this is Bruce Weatherby. I'm just representing myself. I'm not. I had a couple of questions relative to this process and the time it's taking or proposed to be taking. This matter is of large consequence to the public, to the people who live in that area, to the workers in that area. I understand all that. I just find it kind of like, maybe, Mr. Hearing Officer, you and I are old enough. I don't know about the other people here, but this is like after the Mercury mission, saying we're ready to go to the moon and jump right to Apollo without having a sufficient time to really review everything that needs to be done. And I'm not a scientist, I'm not an attorney, but this process seems to, at least, I think the compromise that you pulled together at least gave people an opportunity to respond, and for the public to have some assurance that there was thought put into this and people didn't feel like they were under the gun. And that's the only thing I'd say at this point.
Okay. Well, in any sort of due process consideration, there is not only the issue of the prejudice that might be suffered from those who are, in this case, opposing the application, but there's also the prejudice that could be suffered by the applicant. And I want to hear from you, of course, Ms. Bradford. But I do have to say, I guess I'm prejudging what you're saying. I'm sorry, but I do want the applicant, if we were to stay with this October 19th date, I do want the applicant to keep in mind this is only 8 weeks. This is only an 8-week extension. This is not an 8-month extension. So while there is some potential financial loss, maybe get to the market a little later because of this, assuming that everything else you have planned gets done on time.
Mr. Hearing Officer, if I could.
Short
Yeah.
period. Go ahead.
Yeah, just really quickly, because I too raised that question with my client, getting down to, this is the question that's going to be in your mind. It's a short time period. What is your loss? Starting November 1st, it will be $325 million a month. This project will start to abandon employment opportunities in New Mexico. And there are many kids from the labor unions who want to be placed in jobs, who really want to start working, and those job positions are being held until the project knows about certainty. There are real, imminent, immediate consequences to actual New Mexicans, and we can get affidavits from them and from the project, which you have a declaration from.
All right, I understand that. So,
If I may, Mr. Hearing Officer, just address the discovery. This is Carlos Romo, also with the applicant. We were just served with the discovery on Friday, so we are still evaluating it. We don't think it's appropriate to use discovery as a means to delay this hearing because, first of all, it's not even clear that the Act allows discovery in this type of proceeding, as we've talked about before. That said, we are still evaluating the discovery to try to figure out what is available. We all know that the draft permit and statement of basis will be coming out this Wednesday. We think there's a lot of information that will be included in that will answer some of the questions. We also think that a lot of the discovery requests, other than just being premature, are clearly outside the scope of this hearing. For example, there's several that are asking about water and water demands and waste issues and whatnot. So we know that there's discovery that is clearly outside the scope of this hearing, and that can't possibly be used to delay this hearing, to get that information. So I do think that we'll work with the parties. We'll try to figure out, what information is available. We know the administrative record is going to have a lot of the materials and information that they've had. As Mr. Cox mentioned, they have had the application since May 27th. As an example of one of the discovery requests that they're asking about, they have asked, how do fuel cells work? How do they operate? They've had the information that this is a fuel cell project for over 2 months, and they're still asking those kinds of questions 2 months later. So that information is available online. It's the Bloom Energy website has videos, it has diagrams, it has all kinds of information about how fuel cells operate. So there's no reason to delay the hearing for some of this kind of basic information that is readily available out in the record.
And
Okay.
Mr. Hearing Officer, if I may, just one other thing. Fuel cells actually were invented in the 1970s by NASA. So they've been around for a very long time. It may be a technology that we're not all as familiar with, but they've been around longer than I've been alive.
And Mr. Hearing Officer, this is Mr. Cox. May I be given an opportunity to respond?
Unfortunately, I've been alive much longer than 1970. So, but I understand there are a number of different types of fuel cell.
There are a few different types. This type has been around for a very long time. Yeah.
Some fuel cells that are hydrogen oxygen fuel cells, and the gas oxide that trying to be installed or intended to be installed here. So that's
Mr. Hearing Officer, may I respond to Mr. Romo?
Not quite yet. Mr. Romo, I didn't hear Mr. Cox suggesting that his discovery request was in any way intended to delay the hearing. That's not what I heard him saying. That's not the way I take it, actually. I appreciate your observations on that, and some of the discovery may not be appropriate, and some of it may be, but I didn't hear anything indicating it was being submitted to delay this. So what else? I mean, I'm kind of coming to a point where I want to.
Mr. Hearing Examiner, if I may, we didn't really get a point where we could state our position as the move-in.
Well, go right ahead.
Okay. So during the scheduling conference that we had on July 15th, we discussed the potential hearing date of August 17th. And I think it became apparent during that conversation when we talked about pre-hearing motions that they were just going to be due a few days later. And in that moment, I think hit us all in that conference. Following the conference, you entered an order to start the hearing on October 19th. That means that the hearing will start October 19th, and if it goes for a full week, it'll end on October 23rd. The scheduling order in paragraph 11 allows for 30 days to file post-hearing filings. When you do the math, that means that the post-hearing findings of fact, conclusions of law will be done on November 22nd, which would give 1 day to the deputy secretary to make a decision to grant or deny the permit application. 1 day. Like that is the exact mirror image problem of the 2 days up front, 1 day at the end. But that's an extremely generous timeline. It assumes that the transcript is filed the day the hearing closes. It assumes that there is no officer's report, no objections on the officer's report, and no other filings. And that really is what we are asking, is we're asking to take a realistic view at the post-hearing process and how much time that requires. In reality, when you look at all those steps, they're important steps too of the hearing process. We need time for you all to be able to review the record and make a reasonable decision. And so look at how much time is needed in the post-hearing process. I think it takes about 60 days in the post-hearing process to really get through that. And that's with expediting the post-hearing process. That's with an expedited transcript, shortened timelines for findings of fact, conclusions of law, expediting objections to that, and then giving time for the deputy secretary to review everything and issue a decision. We're talking a lot about meaningful participation and what meaningful participation is. The legislature here created a 180-day process, and we may not like that process, but it is the law. I have not found in the regulatory context, it may exist in a criminal context, cases that say that an agency or agency employees or contractors get to expand the scope of what the legislature has set. In fact, longstanding New Mexico law is that agencies are creatures of statute, and we have to abide by that statutory authorization, and agencies don't have authority to go beyond what the statute authority is. Maybe nobody in New Mexico has tried this issue, but also NMED, for its minor source air permitting program, is subject to a state implementation plan issued by EPA. These deadlines are part of that state implementation plan. And repetitive violations of state implementation plan approved regulations become a basis for EPA to really look at an agency's program. And so routine violations are not a strength. They don't create some precedent, full force of law that we get to blow past things. They actually create major problems for states if the federal administrator wants to look into that. And I think the wise choice here is not a choice between a schedule that follows the law or is able to go past that deadline. We want to find a schedule that's just right, something that's not too hot, not too cold, but something that complies with all of the procedures that are contemplated within the 180-day timeframe created by the legislature. And so when you look at meaningful participation in that process and what the statute and the regulations provide, you actually see a process when you map it out where about 120 of those days go to public participation. So that's about 120 days out of a 180-day process that centers around public involvement in the hearing process. That's not shortchanging the public. That is 30 days for public comment after the permit is deemed complete by the agency, and that period ended on July 6th. And then the agency drafts its analysis, and that should be published on the 29th. And then there's another 30-day review period, and that can run concurrent with parties preparing their cases. If this hearing was to start mid-September, and I understand you said you were out and unavailable early September during our scheduling conference, if it started mid-September, that would give the parties a couple of additional weeks to prepare their hearing filings, to have their statements of intent ready, which complies with the regulatory 14-day deadline set forth in the rules. And then at the hearing, this might be a 1-week hearing. It very well could be a 2-week hearing given the number of parties involved. That is another 2 weeks, public involvement, public participation. But what we're shortchanging, we're trying to rob Peter to pay Paul, is we are crunching the back end of the process. And that is something that due process, doesn't tell us we should do. We give everybody a chance to do certain types of process at certain times. That's not due process, right? That's just scheduling. And we want to make sure on the back end that those parts of the public process are given some attention as well. That involves drafting closing arguments, proposed findings of facts and conclusions of law, which can take 20 to 30 days. And that's part of participation by all the parties here today. That involves hopefully objections on a proposed hearing officer's order, which is participation as well. And that's part of the process. And so when you put all those days together, very little time is actually left to getting the transcript ready, the agency's analysis. If you look at that, it runs concurrent with some of these time periods, but the focus has not been placed on that in the schedule. Your hearing officer's report, and then the ultimate decision. And that's really what we're looking at crunching when we stay at the October 19th timeline. And I want to make sure that at the end of this, the overall process is fair. And we want to have a full picture of the different procedures that need to be followed so that we are not in a situation at the end of this where one party, whoever it is, claims legal error for failing to follow a timeline.
Good. Thank you, Ms. Burnson. My perception of this is that the rules that we have been discussing really were not drafted in anticipation of a case of this complexity. I mean, we are somewhat stuck with those rules, but I doubt that the people who were drafting those rules expected cases of this magnitude to come forward and try to be decided within these rules. I am concerned that the parties opposing this application have adequate time to prepare for this case. And if that means that denying them adequate time will deny them their due process rights, then I am not going to rule that way. And I know, I mean, we're lawyers here, and I don't know that I can do this, but it seems to me to be the correct answer is that if this extension to October 19th that the opponents of the application have requested is granted on their due process rights grounds, then the rules controlling the date of the final decision are no longer applicable. And I don't have any case law on that. It'd be nice if within 2 days the parties would address that issue. If they can find any case law on that issue, I would appreciate it, because my position at this point is that the parties in opposition do need time to the October 19th. The prejudice to the applicant is some, but it's not enough to offset the opposing party's rights to fully prepare for this case. And due process should justify granting, opposing the applicant's motion here in front of us today on due process grounds, and assuming that the hearing date is going to, the decision date is going to be sometimes after November 23rd. Now, are we on new ground? Yes. Can you seek a writ of mandamus? Probably you could seek a writ of mandamus, and I think if you did, then the parties in opposition would have to try and establish a due process right to the extension that I am granting, and the kind of elimination of the November 23rd decision date. And the problem with that is it's going to take you a long time to get that ruling, unless you can get a court to do it expeditious. I'm just looking at the realities of this thing. But at this point, my ruling is going to be that the opponents to the application have a due process right to continue the October 19th hearing date, and with the due process extension affirmation of the October 19th hearing date, the November 23rd date to make a ruling is no longer controlling. And
Mr. Hearing Officer, since you've made your ruling, I will offer a case to you. The citation is 2000 NMCA Court of Appeals.
Okay.
078.
Okay.
It's NM Department of Health v. Compton, as in the city of Compton. Well, it's not the city of Compton, but that's whoever Compton is. But if you look at paragraph 12 of that,
okay,
paragraph 12, it's sort of a little bit of a reverse, but paragraph 12 gives case law support to the idea that administrative deadlines can be extended. They're mandatory when there is no waiver or no good cause. So they can be extended by good cause. And I offer this just to expedite this process rather than to reopen a bunch of, I think more motions. So everyone has a right to file motions, but more motions on this is really going to delay. And so I'm offering that to you as a kind of basis to expedite this process. I think you do have legal basis for this. That's not to say we're taking a position, but just really more to expedite the process. And to further expedite this process, I think that it would be helpful in the department's view if you made a ruling either granting or denying, because I think we have a motion for discovery, what I would call a motion to discovery on the table. I think that you have to order discovery or deny it. We're not taking a position on that. I've heard the parties, and if you want to hear from us, we can, speak about that. And then I'd also like to ask, with the permission of the parties, to maybe think a little bit about amending the October 19th schedule to allow for rebuttal testimony. Because of the complexity of it, it might be helpful to the parties to maybe extend out, we kind of lose some time with regard to developing our direct testimony by, forfeiting 2 weeks, but then we give ourselves another week or 2 weeks to develop rebuttal testimony. That's a request of the department, but, of course, the other parties might have, objections to that or whatever else. But that's in terms of moving this forward. That I would just say, one, in order, either orally or in writing, granting or denying discovery, and maybe we could talk a little bit about more of that. And then, a request to kind of, if not 2 weeks, maybe a week, to kind of help with developing rebuttal testimony subject to the input of the parties. Thank you.
Okay.
Mr. Hearing Officer, if I may, this is Ms. Bradfeud. I mean, my clients are suffering major financial losses every month that this hearing is delayed. And I want to go on the record saying that. So they, of course, want this to go to hearing as soon as possible. Their jobs, and we didn't even hear from the parties with the jobs, those job openings aren't going to post for another month. So those kids waiting on jobs aren't going to get them right now, right? Those are real harms for New Mexicans, every bit of delay that we have. But, I would ask that we accommodate the schedule for the October 19th hearing to move up direct testimony a little bit sooner so that we can accommodate more rebuttal testimony if that's the wish of the department, instead of moving the hearing date further back. We really do need this to go to hearing as soon as possible. The state is at jeopardy to lose the project entirely. And I don't, I'm not blowing smoke as I state that. And then I do also want to say we just got the discovery request late Friday. We haven't even had a full business day to analyze them with our clients. And so we'd prefer to respond in writing to the motion if we could.
Okay, yes, absolutely. And as we had discussed, and I take your point, and again, this sounds a little snarky, Ms. Bertrand, and I don't mean it to be, but it has been stated by some of the opponents to your application, and it is, I think, a fact of business that when you undertake an enterprise of this scale, one that is obviously going to raise a lot of opposition, that's predictable, and you go ahead and you start breaking ground and investing money without having permits in hand, you have consciously assumed the risk of loss. And with the risk of loss comes the risk of delay. I mean, I've started business. I've started wholesale business, and I've started other businesses. I mean, that's the reality of business. You put your money down, you pay, you take your chances on how it's going to turn out. Now, that's Oracle, or the money behind this. The job matter is to me much more serious. I really do regret that, but nonetheless, we have to. Once this facility is in place, it has the potential for being extraordinarily beneficial for the state of New Mexico. Extraordinarily beneficial. And conversely, if it's not thoroughly investigated and it's put in place, you'll never get rid of it because you're going to have too much money invested. It's going to stay there operating for as long as necessary. And so those are the realities on the ground. I mean, this really does need to be, I think, given a pretty thorough examination before we commit to it. And I think giving the opposing parties extension to the 19th of October is good. And again, I'm going to, I guess, I don't know quite how I phrase this, but anyway, I'm gonna enter the order based on due process consideration, and with that due process, then abolishing the November 23rd as the absolute deadline in this case, and that you can appeal.
Yeah,
So that,
no, we will. Thank you.
yeah,
Mr. Hearing Officer, since you've made your ruling, also, and I know I'm taking a lot of air up here, but would you also consider truncating within reason the time for findings of fact and conclusions of law, truncating your time to write the your report? And I know we can't order the deputy secretary to, but you know, in the hopes that we can also ask the deputy secretary to expedite whatever his decision is. And I think, you know, the Air Quality Bureau could probably, if a permit were to be granted, they could probably turn that around. You know, within 24 hours if the permit was not modified at the hearing. And then I'm confident that with there may be a fee, an expedited fee that and it's common that we have the court reporter expedite the transcripts. Thank you. That's all I have to say.
yeah, well, no, we can work on all of those things. And let me, yes, Mr. Hill, I think we can look at that. And going back to discovery, I think we talked about discovery some initially on the last hearing, and certainly the rules do allow for discovery. The way I read those rules, it seems to me that I have a hearing officer have the authority to allow discovery in these proceedings, and it is my intention to allow such discovery subject to the conditions that are set forth in 20.1.4 et al.
Mr. Hearing Officer, and since your major ruling here, I do want to say, and I would, you know, I guess I'm imploring the seeking parties to consider that a lot, not everything, but a lot of what they're asking for will be in the administrative record. And and it's hard because they don't have the administrative record yet. I understand, but that they would consider, you know, limiting what they're asking for, particularly with regard to the department's technical analysis and that kind of thing, because that is the kind of thing that's going to be in the administrative record. And the administrative record is going to be extensive, you know, thousands of pages. If I'm anticipating correctly, we're going to get it out as soon as we can. I will move our team to try and get it out. You know, typically it's been our practice to file it with the notices of intent. If we adjust the timelines, then that possibly gives the parties 30 days to examine it. I will try to get it done earlier without promises. I will go to our team and you know, in the interest of the due process of all the parties, that we try to get it done as soon as possible. I don't know what we can do on that because it's a very large undertaking, but just please consider that it's you know, what's in the administrative record probably shouldn't be sought through discovery.
Well, I hear what you're saying, Mr. Hill, and I'm wondering how helpful that would be to the parties who might need to do some discovery. I mean, if your administrative record's not going to be out and it's 1,000 pages long and it's not ready yet, you don't know when it's going to be ready, can they realistically postpone a discovery request until they've had a chance to review this document, which may not be reviewable for some period of time? And then does that give, assuming that the discovery request is approved, does that give the applicant, you know, a time to provide the discovery request and for then the requester of the discovery to get that information to their experts. I mean, realistically, how do you see that, Mr. Vio? Is your proposal realistic or not?
Is my proposal realistic? I think it is. I can't speak for all the attorneys, but there are attorneys from opposing counsel who they don't know the specifics, but they do know what typically goes into the administrative record. Some of these parties are working together, and that's entirely appropriate. And so they can confer, in my view, if they choose. Again, we're not telling anyone what to do, but they could confer. These are, these are tough, experienced attorneys. This is not their first go around on these permit hearings. So they know what they're doing. They're not trying to delay, I don't think, but they can figure out what I'm saying and limit the scope of their request. I mean, so I do think it's realistic, but again, it's not for us to force them to do that, of course.
And if I may, appreciate that, Mr. Visual. If I may just reiterate that we read the rules 21.4E as only applying to hearings under the Solid Waste Act. And that's the only portion of the rule that allows discovery for those types of proceedings. We don't believe it applies to the Air Quality Act. That said, we would appreciate the opportunity, since these were filed on Friday and that this status conference was really focused on the schedule, to have an opportunity to respond in writing to the motion for discovery, and that we will try to work with the parties and try to figure out if there is a ability for us to confer and come up with materials that we reasonably believe are within the scope of the hearing and that are in our custody and control and can easily send to the parties. So I do think there's opportunities for us to compromise. We've done a lot of discovery. There's always ability to compromise with the other side on something. And some of these requests, I do think, are covered by the administrative record, are covered by the statement of basis and the draft permit, which will come out on Wednesday. And so I do think we'll have the ability to point to some of those items.
Okay.
And Mr. Hearing Officer, may I respond just very briefly to Mr. Vihill's point? The reason that we haven't filed a discovery request with NMED in particular is because we're waiting for their documents to come out, and based on whatever they do publish and when, we will review that and then submit requests as necessary to kind of supplement that. I don't believe that what they're going to release is going to answer every question that I have. I mean, it would be nice if it did, and that's the world I would prefer to live in. But we've been very reasonable with our discovery requests, and yeah, we would appreciate working with the parties to talk about them.
Let me go back to this discovery thing again, because I do realize what this is, what 20 point paragraph E, order for discovery. It does really refer to solid waste. It's just, it doesn't make any sense to me that discovery would only apply to a solid waste proceeding. As I've read through all these rules, there are several that I see. It looks like they just haven't been updated in a while, actually. But I also see that the hearing officer has some discretion in these sort of proceedings. And I think that discretion would be certainly to allow the parties to conduct discovery. So that's my ruling on it. Go ahead. Someone wanted to speak.
Oh, thank you, Mr. Hearing Officer. I was just going to add that I believe that section that references the Solid Waste Act places additional restrictions on how the discovery can be requested, but those are restrictions on discovery specific to the Solid Waste Act, which means it's broader under the other acts and or under the Air Quality Control Act.
And I respectfully disagree, because there's also provisions elsewhere in the NEMAC that apply specifically to Albuquerque and Bernalillo County. And those specific procedures allow in air permit proceedings before the Albuquerque board for discovery. There is no similar set of discovery procedures here. So those could easily be added to the rules. They've been added to the rules in several places, and they're not added to the rules specifically under the air permit proceedings. So I do think the discovery is not allowed. That said, we will respond in writing to the motion, and hopefully, Your Honor, Mr. Hearing Officer, you can look at the materials we provide you and decide what the appropriate scope is once we've responded in writing.
Certainly. Okay, I'm sure we could continue this discussion for much longer, but I think we've hashed out what we've hashed out, and I think I've come to the ruling I'm going to make, and I will prepare something in writing and get that out to you, everyone, tomorrow. And I appreciate your input and your discussions, and you and Ms. Bradford. I certainly appreciate the point of view. If I don't agree with you, but I certainly appreciate it. All right, thank you.